Hello, Matthew East. Thank you for the $2. Speaking of which, I think the stream has been demonetized because we've talked about this issue so much. So I've actually submitted for manual review so we can get the stream remonetized. We'll see how this goes. Very much appreciate your Patreon donations right about now. Someone's asked about the dogs already. Hey guys, are you chewing on your bones? Would someone come here for a Skittle, maybe? Anybody? Nico? Ilsa? Hello? You came like halfway and then stopped. Hello? Can you come hop to get a... Can you come hop? Huh? Oh, good girl. Oh, yeah, that's not... No, but she's down here. Oh, hey. Oh. Hello. Hello. Does Nico want to come here for a Skittle? Nico? Nico might be asleep. I don't know. It is 12:58 here. We have about 2 minutes to go. How's the audio? How's the sync? I will turn down the volume of the music. But I am using my camera for something else today, so I apologize that I have my webcam, I guess you would call it, for my broadcast camera here. Seems like it's going to be okay. Audio is okay, no music. What? We cannot hear music. That's weird. It's transmitting on my end. Really? What music? That's interesting. I mean, our meters are going over here. That's weird. There's no music. It's not transmitting that. Okay. Music does not exist. That's interesting. Yeah, there's properly licensed music and everything playing right now through OBS, so I'm not sure why OBS wouldn't have been transmitting that to stream. But hello everyone, I'm Leonard French, your favorite copyright attorney, and today I'm here to talk about the latest filing in the Imagos versus Alex Mauer case. The court has put an item on the docket that Alex has sent in late, and I thought that this would be a really good time to go over that because a lot of weird stuff is about to happen. Steven, thank you for the $5. Never thought I would enjoy watching a lawyer's live stream. Love the videos. Keep fighting for us. Thank you very much, Steven. Appreciate that. So, everyone can hear me. Is that correct? Even if for some reason you couldn't hear the music that I swear I was transmitting. But, okay. Oh, you know what? We also have YouTube chat. Let me see if I can put the chat on the stream because that's always appreciated, right? That's kind of a fun thing to have. There we go. So I'll have to make sure I make that visible as we go. Somebody yell at me. Can hear you fine, voice good, audio great, awesome. Thank you very much. So what I'm here to talk about today is this document. Thank you, Mo. Appreciate the 10 euros. I'm here to talk about this document, which was Alex's response to the complaint. This has now been filed, it is now public, and I now know how the court is treating it, and I'll go over all of that in a moment. So this is her response. It is a simple one-page response. It was sent in to the court, at least based on what was sent to me. It was sent into the court at least 3 hours after I filed the notice of the entry of default and sent a copy to Alex via email. So first thing I thought could this possibly have been even written, by the 26th, that maybe she wrote this starting after I sent her an email that we were going to default her. So it sort of looks like a response. I can't deny that it's some kind of response. It says that Alex worked for Don in 2015 and part of 2016 writing music for a video game called Star Mazer. It says that she was supposed to be a partner in the company, but Don never produced the contract that would have made the arrangement legal. Instead, Alex worked under a contract that was a film crew form in which Alex was a freelance contractor. Alex was supposed to be the music composer, and she did that. In fact, she was constantly ahead of the rest of the development team, so that she was given other tasks mostly involving appearing on an online TV show to promote the game. As Alex has stage anxiety, this was great stress. Alex also moved to Seattle at the behest of Don Thacker. Shortly after Alex was there, the publisher for the game backed out of the deal, and Alex became extremely anxious as Don was having trouble paying members of the team. Alex suffered panic attacks and moved back home to PA. Alex and other team members tried to advise Don that the game was too complicated, and eventually it was apparent that the game Star Mazer was running into problems. So Don decided to make a new game, DSP. This game could raise money for further development of Star Mazer. By the time Alex started working on the DSP contract for work on Star Mazer, started working on DSP, the contract for work on Star Mazer was expired. Alex asked for a new contract several times, but Don never produced a new contract. She then goes on to make some bullet points here. The original contract was never fulfilled, inasmuch as Alex was not paid in full for the amount of work that she did. Alex contends that Imagos owes her $9,000. Alex waited for nearly a year while being promised more pay, then asked for her music to be removed from the game DSP, which was done. Alex tried to communicate with Don and his attorney, but was given no response for 2 months. Out of frustration, Alex warned that she would take down videos from the internet with her music from DSP on them. There was no response. Eventually, Alex took down videos with DSP music on them. There was no response at first, but then Don's attorney, Mr. French, began making YouTube videos about Alex, and there was a sudden outburst of hate mail directed at Alex. Defendant asks that Mr. French cease and desist from making videos about the defendant, as this was resulting in hate mail being sent to defendant. So, and then there's it's signed here at the bottom, and it says, "I hereby certify that this document was served," and signed there at that line as well. So it's a very interesting response. Scroll down. Yes, you would like me to scroll down. There is the full text, which I will leave on the screen so you can see. You know what I will also do? I will also put a link in, I guess, the chat and the description so that someone can download this for themselves. It is on the docket. There is no... I can't prevent people from getting this, and I'm not going to try, so I might as well help you, right? So give me just a second, and I will throw these on my website and then give you a link. Copy as path. Copy as... Oh! Why are you... It's closed. Go! Oh, yeah, for some reason it doesn't want to let me open... Oh, that is annoying. Oh, well, I can do it another way. Windows has not been kind to me this past day. I'm not sure what's going on. They made some updates, and now all of a sudden so many things don't quite work properly. I have no idea. I really have no idea. I couldn't connect to a GoToMeeting yesterday through Chrome, and when you go to GoToMeeting with a different browser, it tells you must use Chrome. So I don't even know. Okay, so here we go. Here is a URL that you can use to view the response. I don't think there's anything in here that needs to be redacted. I'm not too worried about that. I'll post that in the description of the video as well, and then I'll change that link to. I won't change the link. I'll update I'll update with a new link when I write a little thing for my website about it. So, pro se can lead to some fun arguments. I guess there's it's not that I don't know where to start. I guess it is that I don't know where to start. There's so much to say about this. First, I'm doing a live stream right now first because it's going to take me a few days to write the formal response to this. And we'll go over why in a moment. I'm going to make, like, if you were looking for the epic legal response, this is not it. I'm going to have to write an epic legal response to this, and we'll go over that in a moment. Yeah, so Tactical brings up a really interesting question. This is not about copyright. Where is copyright in here at all? So let's go over this line by line. Alex worked for Don in 2015 and part of 2016. Okay, that sounds possibly correct. You're going to hear me using equivocating language because I don't want to affirm anything that she's saying here without first going through my legal research. So, but I am going to deny a bunch of it. Alex was supposed to be a partner in the company. Yes, denied. Alex was never supposed to be a partner in the company. Maybe Alex had talked about it or something. I don't know. But Dawn has made clear to me that she was never ever meant to be a partner in the company, like an equity partner, having contributed capital to the company that's paying her. No. Equity partners are investors who have money, who contribute money to be a partner in the thing. So Alex has to do the work and have a good relationship and have a good thing going, and then maybe in the future. That's how that works. Like, for lawyers, for example, you hear about lawyers who are partners all the time. It's the same thing. It's the equity partnership in a law firm. You don't go get out of law school. You don't even get out of a legal career, really, and just become a partner in a firm. You usually work for the firm and are tremendously successful at the firm, so much so that the firm wants to keep you by offering you to become part of the equity partnership of the firm. So no. Also, when these things, when people become partners in a company, there have to be documents. There's literally laws around this called the Statute of Frauds and other formation laws that say that you can't just make a oral agreement to make somebody a partner. So if Alex was unhappy that she was not being made a partner, that's one thing. But there's no legal allegation here that she was in any way a partner of Don's anything. Instead, Alex worked under contract, which was a film crew form. I think it's true. I think Imagos Films is the form, that Alex was a freelance contractor. Okay? So she admits that she's a contractor. Alex was supposed to be the music composer, and she did that. Okay, so she was supposed to be the music composer. She has composed music. We all have heard her music. Or at least we can go hear her music if we can search for it enough. I think it's still up in places. In fact, she was constantly ahead of the rest of the development team. I'm going to say salacious. I'm going to say that doesn't have any legal consequence. I don't believe it to be true, but I don't even know because why would I care? So much so that she was given other tasks involving appearing on an online TV show to promote the game. I do believe she did appear on the game promotion videos. I'm not sure how much of that was at Alex's objection or at her claiming that this isn't in my contract and I don't want to do this. So I'm not sure what the sentence means other than that she's a little butthurt that she didn't speak up. I don't know, maybe she regrets that she didn't speak up and say that she didn't want to be on the thing. I have all the sympathy in the world for somebody who doesn't want to be a performer and live. I mean, it's just definitely stressful to people who aren't used to it. Heck, it's even stressful to me when I'm having an off day. I don't want to get in front of the camera here and talk to you. You're going to see that. You're going to see the cracks. You're going to see that I'm a human. I don't want you to see I'm a human being, do I? Huh? Anyway, so as Alex has stage anxiety, this was great stress. Okay, I can neither confirm nor deny this without the permission of my client. Alex also moved to Seattle at the behest of Don Thacker. I do recall that Don and I had a conversation about this. I don't know that it was at the behest of Don. I think it was a mutual agreement, and I believe that Don actually flew out to Pennsylvania to drive with Alex to accompany her all the way out to Seattle by car because she didn't want to go by plane. I don't know that it was that she didn't want to go. I think it was that she didn't want to go by plane. But once again, I can neither truly confirm or deny these things without the confirmation of my my client. Shortly after Alex was there, the publisher for the game backed out of the deal. Well, these next couple sentences sort of speak out of order, in my opinion, and I believe fact will show this, but I'm also going to make some arguments that we don't have to show these facts. So that's another reason why I'm doing this. Shortly after Alex was there, the publisher backed out, and Alex became extremely anxious as Don was having trouble paying members of the team. These are sort of out of order. Don started having trouble paying members of the team after Alex began asserting ownership of the game and telling, like literally calling and emailing and writing and telling people that she owned the game. This began privately, more privately, a year or more ago, not just this summer when she started saying things publicly. These problems began occurring a long time ago, and the publisher actually backed out later, not earlier in the chronology of things. And the having trouble paying people was as a direct result of Alex and some of her things that she was saying. Yes, it's possible that there were some normal business delays in paying people or something. I don't really know what the timing was. If there were, is it possible that Imagos sent Alex a check a little bit late? Yes, it's possible. And if that's a big problem, she has remedies to bring all of that up. Here she's just saying that that's what happened. So I again can neither really confirm nor deny that any of Alex's pay arrived late at all, but there was definitely no withholding of pay, and there was definitely no, nobody's ever going to get paid again until Alex made a really, really big stink about how she had to own the game or part of the game or the music in the game because she wasn't paid again after she left voluntarily because I'm not going to go into the personal circumstances of it, but after she left voluntarily. So she then goes on. Alex suffered panic attacks and moved back home. This is actually, again, quite a violation of the factual chronology. Alex, I don't know anything about panic attacks. She was definitely going through something, according to what Don was saying, but it seemed to be more that Alex was going through it, and Don and company were trying to help and appropriately react and support Alex. So why she would turn and say that they were not, I don't know. If I recall correctly, she moved back home voluntarily and not because anyone made her leave or stopped paying her or anything like that. Alex and other team members tried to advise Don that the game was too complicated, and it eventually became apparent that the game was running into problems. This is really just completely untrue. The game is not too complicated. Don actually had sent me something here in response to that allegation. He's in the middle of working on a project right now, and we're going to have him and Lindsay on stream here at some point soon, but this is all happening very, very quickly here. So he wants everyone to know that Star Mazer was going to be late, and they were super clear about that. They made updates in media, on streams. They were active with their fan base to tell them that Star Mazer was going to be late. That DSP was a joint effort between Imagos and Pixel Jam. As I've said before, it sprung from the shmup elements. You've seen that DSP is just the shoot 'em up part, and Pixel Jam was helping with Star Mazer. They found out that this one set of gameplay elements, the shmup elements, was extremely fun, and decided to release that as both like a tech demo and a prequel, and kind of kill a whole bunch of birds with one stone. But the most important part, whether you agree or disagree that that's the way it should have been done, the most important part was that DSP was not in any way released as a answer to monetary problems. DSP was released during active development when everyone was being paid and everything was fully backed and fully funded. Let's go over what Alex says. Alex says that Don decided to make a new game, DSP, to raise money and further development for Star Mazer. The project was fully funded, and everybody had everything they needed to complete the game. And Alex began making claims that she owned things, and that. And she got investment partners to back out, and basically killed funding for the game. And now she's here complaining about how there wasn't money then left over to pay people. It's a very interesting twist of the facts. DSP was paid for by playism, Don says. It was started in earnest at the time. Not just demos and playing around, at the same time as our publisher contract with them. At the time of DSP being official, a game we're going to release, it was paid for, and so was Star Mazer proper. Alex was paid fully for her work, for the work she completed on DSP under contract, and she did the work knowingly. And then he just asks me to read that. So thank you very much, Don, for responding with that, so we could have some of your answers to some of these things here on such a short notice live stream. So Alex goes on to say that by the time Alex started working on DSP, the contract for Star Mazer had expired. I don't know that the contract on Star Mazer had an expiration date. It was for a project. It was a project contract, and project contracts that don't have expiration dates written into them don't have expiration dates written into them. It's not rocket science. Alex asked for a new contract several times, but Don never produced a new contract. I don't know. I have no knowledge of whether she asked for a new contract several times. Certainly, no one produced a new contract because she was working under a contract, and then she stopped working under the contract. So why would you then need a new contract? Either way. So she does admit that she worked as a freelance contractor, which would confirm her work for hire arrangement. So I feel like she's sort of admitting my points and claims anyway. Then she goes on. The original contract was never fulfilled inasmuch as Alex was not paid in full for the amount of work that she did. That's true. The amount of work, the amount of pay that she was paid is allegedly proportionate to the amount of work that was completed. There was still some work left to be completed, and she has not been paid about the last 10% of I think it was $40,000 contract. So I think if she had completed her work and none of this had happened, she would have been due about $3,000 or so. $3,600 was a high number I saw. $3,000 was a low number. She's saying 9, and yet I still have not seen a consistent or coherent itemization of that $9,000. I've just seen various invoices that have line items, and the line items change, and they say things like for uncompleted work, and it doesn't really go into extreme detail as to what specifically the $9,000 was for. Anyway, Alex waited nearly a year while being promised more pay and then asked that her music be removed from the game DSP. I don't know what that what that is. She did then ask for her music to be removed from the game. It was not done because she does not own it, because Imagos owns it and has the right to put it in the game. The only reason why the music was finally removed was as a legal maneuver to ensure that she didn't even have anything in the binaries that were released, so that she could not even claim to have ownership to that. So, and if you recall, she not only took down the game for having her music in it, she took down the game then for having files that weren't that weren't part of the playing of the game, like music files that were in the library, in the binary, but were not actively used. You can imagine during development, you have a folder of live assets and you have a folder of, say, deprecated assets, and it's very possible that you could leave a deprecated asset in the thing, and it gets zipped up into the binary and forwarded to everyone without the, you don't even really think about it. It doesn't get performed. It's not getting publicized. So when you figure out your mistake, it's like, so what? So she took it down for that too, and then she tried to take it down again for having matching artifacts, just like strings of ones and zeros basically that had matching hashes to her songs or something, or parts of her songs. The way Steam explained it is that they were incomplete. They were not music files. They were just like leftover artifacts or something. I'm not even entirely sure. So she tried to take it down for that. So the legal maneuver was for us to remove everything from the game that could possibly have anything to do with Alex, and to also write the DMCA counter notice in such a way that all works were covered by the counter notice. And so that got the game back up on Steam. And we have every intention of releasing the music that Alex contributed to the project under her contract at some point with the project, with Star Mazer DSP or Star Mazer proper. I'll let Don make all the creative decisions on that one, but it is my understanding that we have every intention of using the assets that we've paid for. We're just waiting until we have something that carries a little bit harsher of a punishment should Alex decide to violate it. So how are we doing? We still good, stream? All right. So she then goes on, let's see. Alex tried to communicate with Don and his attorney, but was given no response for 2 months. I think that's very possible. It's very possible that after years or more than a year of dealing with this, that there was one point at which nobody responded to her for a while. Gee, after you've seen how she behaves on Twitter, can you imagine someone not responding to her? She's just a ball of sunshine. Why wouldn't anyone not respond to her? Out of frustration, Alex warned that she would take down videos from the internet. Whatever. She took down videos that had anything to do with DSP in them. Eventually, Alex took down videos, so she's admitting our allegations here. There was no response at first. Like, okay, so what? What does this mean? You take down videos in order to get a response. She's admitting our allegations. There was no response at first, but then Don's attorney, Mr. French, began making YouTube videos about Alex. Great, I have a First Amendment right to make YouTube videos. The court is not going to order me not to make YouTube videos without you explaining why. There was a sudden outburst of hate mail directed at Alex. Okay, that's at least an attempt at explaining why, but that's not a legal claim. That's not saying that I said things in my videos that warrant me not to be allowed to make videos. Defendant asks that Mr. French cease and desist from making videos. So that's really weird, because that's like a claim for relief. So what is that? Like that what she's in court on the contract thing. Okay, maybe I could see the court reading the first bullet point as a claim as well. So there's a claim for $9,000. There's some kind of defense, affirmative defense, that she only took down the videos because she thought she had a copyright claim. It doesn't say that, though. So she only took down the videos because she was being promised more pay. So that's it. That's right there. She's admitting that she doesn't own the copyright. And then the only real claim for relief, because then the bullet points 3 and 4 are really just prose. They're not claims. Even bullet point 2 really isn't a claim. So bullet points 1 and 5 are really the claims. Why am I doing this? Why am I trying to figure out what this is? Well, because in the federal rules of civil procedure, we interpret the pleadings on a notice standard here. So the federal pleading standard is sufficient notice to put you on meaningful notice that you have a claim or defense or something being made against you. So in this case, the court has recognized this informal response. I don't mean it in a derogatory way. I just mean it is not in the form that the court requires. But whatever, it's pro se. We've seen worse, right, James Romaine? It looks to me, and the court is treating it as a response, as an answer, and as a counterclaim. So, and it looks like there's some defenses in here. So the answer would also normally contain the defenses, but it's also just called an answer anyway. So yes, as Syria points out a good point. I bet she's watching. Yes, I'm doing my very best not to help her, but at the same time, I also want to get to the epic response that I'm going to be making. So there's a lot of things in here. She admits some things. It seems like she denies some things. It seems like she makes a counterclaim, and it seems like those counterclaims are for $9,000 and for me to stop making videos. Okay? So this is this is a bit interesting. Tactical. Do her statements mean anything without evidence? Does she need to provide proof? Yes. So where are we? So because she has made this response, even a late response, we are still in the pleading stage of the trial. You have pleadings, then you have discovery, then you have any pretrial motions, and then you have trial. And so we are not even in the point of the case where I get to make I get to make depositions, take depositions, send questions, and ask her for admissions and things like that. Not that I don't think any of that's not going to be I think that all of that's going to be a shit show, but whatever. Anyway, so what do I think I want to do about this? And again, I'm saying this all publicly with permission of my client because we're not going to be able to make a response until a few days from now, till I'm able to write all of this up in legalese. And even then, you know, it's going to be interesting to see it play out, but it's still going to take some time. So let's go over here to Firefox, and let me put my camera back up here where I like it. So this is, actually we'll start here not with Rule 11. We'll start here with Rule 12. Let's start with Rule 12. Lawyers will know why. So Rule 12 is a very, very important rule of civil procedure. It is the rule that governs defenses and objections, how to present them, how to make a motion for judgment on the pleadings, etc. So there's some very, very important things in here. And so one, I'm going to be making some kind of motion to dismiss or strike her filing as untimely. Not entirely sure that falls under 12A, but there was definitely a court order that said that she's not allowed to, or that she has to file by September 25th and has to get an attorney by August 21st. So 12A is the time to serve a responsive pleading. Usually a defendant must serve an answer within 21 days or within 60 days under other circumstances. For instance, a waiver of service gives you 60 days. So again, I'm not sure that I can respond under 12A, but I'll definitely include the fact that she has responded late, and hope to have her response struck or dismissed simply based on it being unforgivably late. She had since July 19th, actually since before July 19th, since 2 weeks before July 19th. Even earlier than that, she knew that she had this case against her, and she saw the complaint. And she knew that she had a deadline of July 26th to respond, and the court gave her even more time than that. I believe she was even even advised by her attorney that she had until July sometime to respond. So she's been on notice about when she has to respond. And then she went to court on July 19th and asked for more time, and the judge gave her till August 21st and September 25th. And this is basically an unforgivable lateness. Also, a party must serve a counterclaim within the same 21 days or whatever, so I can also ask to strike her counterclaims as being untimely filed. So then there's 12b, which is how you present your defenses. So this is what you would do on a motion to dismiss. Now, she has not filed a motion to dismiss, but she has made something that is arguably a counterclaim, so now I have to file a motion to dismiss. So here are the reasons that I could file a motion to dismiss under Rule 12b. It says here, every defense to a claim for relief in a pleading must be asserted in the responsive pleading. So I'm going to respond to this pleading with a responsive pleading. It will contain, among other things, a motion to dismiss or to strike her counterclaims. One, it could be for lack of subject matter jurisdiction. One of her claims has nothing to do with copyright law or really any law whatsoever. So maybe we have a 12b1. I don't know. But that's also more to do with the court not having subject matter jurisdiction. So that's not really what that's about. So subject matter jurisdiction and personal jurisdiction and improper venue are more about the location of the court and the power of the court to hear the thing. 12b4 is about insufficient process, and 12b5 is insufficient service of process. So those are the summons. When you file a complaint, you get a summons, and the summons packet with the complaint and any documents all have to be sent together. So insufficient process would be if that is somehow insufficient. Insufficient service of process would be if the service of those things upon the defendant is somehow improper. But 12b6 is the big one here. 12b6 is failure to state a claim upon which relief may be granted. I'm going to zoom in a little bit here, I think. I know some of these attorneys. Actually, I went to school with Victoria. Oh, that's so cool. Anyway, not law school. I went to, I don't know, we went to the same church, actually. I don't know if we went to the same high school. We grew up in the same area. That's really cute. I think she works for a local firm now, actually. Anyway, so 12b6 is a really big one, so I'm going to take a moment to go over that. 12b6 is failure to state a claim upon which relief can be granted. There's two parts. So first is failure to state a claim, and so that's any time that you state something like Alex has stated, but doesn't make a claim. So she's told a story, but has she made a claim? So that's one argument that I get to make. And the rest of it is upon which relief can be granted. Failure to state the relief that can be granted, or failure to state a claim that has any relief that can be granted. So, for example, stating a claim that Leonard French should stop making videos is not really something the court has the power to do in a case where no one's made allegations that Leonard French has done anything wrong. So that's also something that we could do. So you can expect to see a motion from me for 12b6, failure to state a claim. Then 12b7 is failure to join a party under required joinder, Rule 19, not applicable here necessarily. A motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. So that means that she can't now make these defenses. She has waived these defenses by making her pleading. She has not included these defenses in her pleading. She has not made a motion to dismiss. These are now waived. If a pleading sets out a claim for relief that does not require a responsive pleading, an opposing party may assert at trial any defense to that claim. No defense or objection is waived by joining it with one or more other defenses or objections in a response pleading, whatever. So then there are some other things in 12 here, in Rule 12. Motion for judgment on the pleadings. So after the pleadings are closed, but before trial, and definitely not an early enough, definitely not late enough to delay trial, you may move for judgment on the pleadings. And these are all different things. These are summary judgment, judgment on the pleadings, default judgment, judgment non-pros. There's one or two others, are all different things. And I realize that many of you say summary judgment to mean everything, and that's fine. I have no problem with you saying that. I can't say that, so I'm going to go over how each and every one of these things are separate. So that's a motion for judgment on the pleadings. 12D, result of presenting matters outside of the pleadings. If matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment. I probably never used that before. I'll definitely be taking a look at that one. What summary judgment standard is that the pleadings will be taken, will be judged in a light most favorable to the non-moving party, meaning if I make a 12D motion to get rid of something outside of the pleadings, the judge will look at her pleading in the most favorable light when ruling on my motion, and then if my motion is denied, we would continue. Motion for a more definite statement. I could include this, a motion for a more definite statement, requiring her to be more detailed in her response. I might include something like that as an in the alternative kind of thing, because you generally get one motion to dismiss. I'm not going to make a motion to dismiss and then a motion for a more definite statement, so I'll probably include all of that in my one motion. Then we get to motion to strike under 12F. Motion to strike. The court may strike from a pleading any insufficient defense or any redundant, immaterial, impertinent, or scandalous matter on its own or on motion. So I'll be making part of my response will be a motion to strike, and I'll be asking to strike all of the stuff that's in her pleading that isn't a response to our allegations, that isn't a counterclaim. And I'll also be asking the court to just strike the whole thing because it's late. It's just absolutely late. It's meant to delay, in my humble opinion. She had all this time to do this, and this is the most that she's done in 2 months. She didn't even tell the court, hey, I'm having trouble finding an attorney, or hey, I need more time, or hey, anything at all that I know of, that I was ever served with. So I don't think the judge will let her just win because she's done a minimum job while I'm having to do a maximum job over here. So then there's this thing called Rule 11, signatures. Well, she signed it. Yes, she did, didn't she? Signatures. Every pleading, written motion, or other paper must be signed by at least one attorney of record, and in that attorney's name, or by a party personally if the party is unrepresented. The paper must state the signer's address, email address, telephone number. Unless a rule or statute specifically states otherwise, a pleading need not be verified or accompanied by an affidavit. The courts must strike an unsigned paper unless the omission is properly corrected. So, believe it or not, she was given a chance to correct the, you may have heard, that she did not sign the pleading originally. However, she did not sign the pleading the pleading that she did not sign was not a pleading that was filed on time. It was a pleading that was filed 3 hours after, the day after it was due, and 3 hours after I filed for the entry of default judgment and sent it to her via email. So, under Rule 11b, by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or just later advocating for it, an attorney or unrepresented party certifies that, to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, that it is not being presented for an improper purpose, such as to harass, cause delay, or needlessly increase the cost of litigation, that the claims, defenses, or other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law, that the factual contentions do have evidentiary support, and if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. That the denials of factual contentions are warranted on the evidence, or, if specifically so identified, are reasonably based on belief or lack of information. If you do not present pleadings that are in conformity of Rule 11A and B, I can ask for sanctions. In general, after notice and a reasonable opportunity to respond, the court determines that 11B was violated. The court may impose an appropriate sanction on any party that violated the rule or is responsible for its violation. Absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee. So I will be making a motion for sanctions as part of my motion to dismiss or strike her response. A sanction imposed under this rule must be limited to what suffices to deter the repetition of the conduct or comparable conduct by others similarly situated. The sanction may include non-monetary directives, an order to pay a penalty to the court, or, if imposed on motion and warranted for effective deterrence, an order directing payment to the movant of part or all of the reasonable attorney's fees and other expenses directly relating to the new violation. So I'll be asking the court to impose monetary and injunctive sanctions. What's the word for that? Equitable sanctions? Somebody in chat tell me. I'll be asking the court to impose sanctions on her, arguing that her paper was presented late on purpose in order to impose unnecessary delay, that the allegations in it are meant to harass and needlessly increase the cost of litigation. And probably citing the other rules as well. But you can see from our perspective how that would be what she's trying to do. Yeah, that's what I thought. Equitable or injunctive relief, right? Just felt weird to say it in that sentence. So then, there's been a lot of questions about contempt. There was an order, not just a federal rule of civil procedure. Let's go back here for a second here. Actually, let me take, because I've learned my lesson about searching the internet on stream. I think it might be in Rule 12. It is Rule 12. I already had that up. So in Rule 12 here, it tells you that you have 21 days to respond to a pleading after being served a summons or complaint. So if Alex failed to respond after 21 days under Rule 12, then she would just have been in violation of Rule 12. And if she then got her response in late, I could see the judge allowing her response to be late and it not being contempt of court. However, she went to court with an attorney on July 12th, I think it was, and then she went back to court on July 19th without an attorney, having fired her attorney, who was doing a decent job trying to help her. I talked to him. He was doing a fine job trying to help her. He was focusing on the issues that were really in the heart of the case. So then she asked the judge for more time, and the judge gave her from July 19th, he gave her till August 21st to get an attorney. He gave her 33 days to get an attorney, and then gave her another 28 days to, no, more than 28 days, gave her another 30-some days, 35 days to get her response in. So she's had 2+ months to respond, and that was a court order. I can bring this up on stream here, I think, someplace. Somewhere. TRO. Where's the one from the 19th? There we go. Oh, nope, this isn't the one from the 19th. Hang on. It's definitely here someplace. Here we go. So this was the July 19th order. This is an order of court. This is not a federal rule of civil procedure. So Alex has violated an order of court, not just federal rules of civil procedure. So we get to ask also then for civil contempt. Now, I know a lot of people have asked what that is. Civil contempt sanctions are designed to compel, Civil contempt sanctions are designed to compel future compliance with a court order. They are coercible and avoidable through obedience. Thus, may be imposed in an ordinary civil proceeding upon notice and an opportunity to be heard. Neither a jury trial nor proof beyond a reasonable doubt is required. So, basically, another definition, or another to add to that, contempt of court is the act of disobedience or disrespect towards the judicial branch of the government, or an interference with its orderly process. It is an offense against a court of justice or a person to whom the justice functions of the sovereignty have been delegated. So this gives the court power, and the court has the inherent power to hold Alex in contempt of court if the court finds that she violated the order, well, one, at all, but especially if it finds that she violated the order for good cause, without good cause, out of bad faith, with the purpose of delaying, out of negligence, just out of plain negligence. The court could fine her or order her new pleading, responsive pleading, to just be struck. And that's what I'm going to be asking the court for, is that the appropriate response to this late pleading is just to simply strike it, and she'll suffer the normal consequences, the natural consequences of her actions. If the court is to allow this pleading, then we are highly prejudiced. In other words, we're suffering unfairly, because we now have to respond to all of these salacious allegations after she's been given 2.5 months. You know, where was there anything? What did we get? Did we get anything? We didn't get anything. We got to suffer for 2.5 months while everyone's waiting to see what happens, and Alex then gets to just get it in the day after, and after I told her that she had to get it in, or that she forgot to get it in. So, yeah, I have a lot of trouble with this. So, just to be clear here, I'm going to be asking the court for a motion to strike or dismiss the all or part of her response. I'm going to be asking the court for sanctions, monetary and otherwise, for the damages done by the lateness of her response and the intentional delay, what I believe is an intentional delay that is meant to hurt the case and hurt the plaintiffs further. And I'm going to be asking the judge to hold her in contempt for violating his order, again with the purpose of intentionally delaying and harming the plaintiffs even further. So I expect that the judge will grant some version of my request. At the best I could hope for is that the judge will grant my request for monetary sanctions and strike her complaint or her response and hold her in default. And maybe hold her in contempt. I don't know if the judge will give me everything. The judge will probably tailor his order to something that is more narrow than what I'm going to ask for, because I'm going to be asking for a lot. So the judge will probably do something like hit her with some monetary sanctions, or require her to post a monetary bond before going forward with the case. Or maybe he'll just have her suffer the default, and we'll go through with our default judgment proceedings. So, wow, that's a lot. Holy mackerel! I've been going over this for an hour now, and I don't even. It doesn't feel like I've been going over this for an hour at all. That's just nuts. So how about questions? I'll put some music on in the background that none of you can hear for some reason, and I'll answer your questions. Does that sound good? Oh, you know what it could be? I wonder. No, I really don't know why VLC would not be outputting to the right. Maybe I'll just check and make sure that audio is going out to the right places. Because you hear me. I know you hear me. That's the default device. And recording. Yeah, that's fine. Yeah, we're good. So once again, I'll put this up on the screen. Not that. This is Alex's response, the meat, the text of it. So you can see, and there's a link there if you wanted to. I am not wearing a hat because it's a different kind of stream. I tend to do the hats on my streams. This is a stream that involves my client, so I'm wearing a shirt with a collar, and I'm nice and clean and clean. Well, mostly clean shaven. So also let's hold VLC in contempt. Yeah. Let's try this again. Okay, on my end, there is a meter that is playing music, and it is as loud as I am speaking. So what don't you hear, people? In fact, when I have it this loud, I usually get asked to turn it down. The link already broke. I'm the one, it's my website. We have a nice farmer's market here in Allentown. I'll be visiting that sometime soon, I'm sure. Let me, yeah, this is weird that wouldn't be. You know what I'll do? I'll just make a quick post on my website. Thanks to Pierce Brosnan for the Norwegian kroner 100. I saw you give 100 before. I really appreciate you, and I know there's a bunch of you that have given as well. I'll actually be able to go over your super chats here in a second. So wow. So Matthew East, thank you for the $2. Stephen Wilson, the Canadian 5. Mo G, the €10. Your Pierced Brosman, your earlier 100. Stephen Wilson, yes, we did cross into a Phoenix Wright game here. Doom 89, £2. Hi Leonard, love the videos, keep up the good work. Tactical Broad, do her statement means everything without evidence? Does she need to provide proof? We went over that. Yes, she does need to provide proof eventually if we allow these things to even go through. If we get rid of these things, then there's no need for her to provide proof because the court will assume that she was given her opportunity to provide proof and neglected it. Lori Barnes, thank you for the Canadian 5. Love your work, Leonard. Hi, Sid Alpha. Jinso Defiler, need to fix the links. Yes, thank you. Alyssa, the Bucks County, the markets in Bucks County are awesome. Thank you very much, Alyssa. Feel free to say hi anytime you like. The link. Yes, back to the link. Okay. I will have to update all of this later. Not Mauser, that's a gun. Wow. There we go. Okay, that's published. And I'll put a new link right here. And I'll put the new link in the description. No music, huh? Somebody tell me if music just came on. I changed a source. Again, OBS is the thing transmitting, and it's right there. It's going back and forth. Oh, I love you all. Yes. A 6.5 Creedmoor Swedish Mauser, huh? Is that what that is, Creedmoor? 6.5 millimeter rounds? No music. No idea why. That's so weird. That is so weird. Is it set up as it maybe hang on, maybe it's set up wrong in the settings. Desktop audio device. Okay, I'm going to put it back to the thing. Apply. Okay, it's still going. Now, there's absolutely no reason why this shouldn't be working. Thank you, Henry Lonewind, for the 404 euros. Appreciate that. Thank you, Svinning Torrestal. Torrestal. Sveinung Torrest. I don't know. Thanks. I'm not entirely sure what Alex's submission is supposed to accomplish beyond causing nuisance. Thank you for the Norwegian kroner. Leo Wattenberg, thank you for the Danish kroner. Danish kroner is greater than Norwegian kroner. So why wouldn't I be asking for jail time, Captain Pipsqueak? It's not that it wouldn't, be nice to get, but I do not believe that we'll be getting any sort of relief in the form of jail time. I also don't think that would really help Alex. Maybe it would punish her. Maybe it would make. I personally, and I think Don believes as well, that level of punishment just might be too much, and even if we could get Alex into jail based on what she's done, I'm not sure that we would want to do that. And it's not saying that Alex couldn't do more, and I personally wouldn't mind having to appear at a hearing where she was charged for the threats that she made, but then the judge would probably still decide that jail is not appropriate for those threats, and instead there would be some kind of community service or restitution or something. I don't know. Charles Miller, should you really ask the court to strike the parts where she admits to plaintiff's allegations? No, but I have to make all the arguments in the same document. So you'll see when I release it, of course, we'll go over it. But you'll see that I'll be making arguments in the alternative. If the judge doesn't want to dismiss it outright, then I do want the judge to be striking only parts of it. Thank you also, Admiral Zarakas, Norwegian Kroner 100. I only saw this now. We'll go back in time. Yes, this will be posted. Curious to see if I'm allowed to monetize it. Apparently I've been demonetized, so I really appreciate all of your Patreon support at this point, as these Sunday morning live streams and live streams in general seem to have been demonetized. I'm not sure why. We're just going over legal documents in a weekly show. So thank you also to Mr. Torrestal again for another Norwegian Kroner 100. The Scandinavian money war has been won already. Yet it seems to still be going on. Tactical says that Alex has been evaluated against her will, and it is very hard to force a person to get therapy against their will. Yes, that is absolutely true, and is a reason why we really can't do anything more to ask the court for psychological intervention. We're not the appropriate parties to do that. It is her relatives and family, and most we can do is show some human compassion. That's about it. No idea why you can't hear my music. It's such nice. You know what? Here's what I'll do. I'll add it as a separate audio source. Audio input capture? Does this work? Nope, that's not it. Remove audio input capture to mute desktop audio, add audio output capture, and use this. All right, you guys tell me if you hear music now. Oh, now I'm echoing? What? Oh God, how am I echoing? Okay, is it loud or is it too loud? That's the question. Yeah, this was just OBS being dumb. Sorry, guys. Here I was rocking around to the music the whole time, in the beginning at least. A little bit loud. Yeah, I'll turn it down. Somebody's yelling outside. Ah. There are so many of you. I love you all. Thank you to Patrick Hogan for the $15. You're all wonderful. Now it's too silent. No, not that much. And the chat goes wild. Canadian tipping war. Yes, it's apparently what we're having here. Yeah, the webcam, I know the webcam isn't the greatest, but I'm using my, actually I have to get ready. I'm using my camera in this configuration, I think, to, here, I'll put you on full screen. My camera's in this configuration here. My mother is being recognized by her student athletes. She is a employee of one of the local school districts, and one of the students nominated her for an award for how kind she is and how compassionate and caring and giving she is. So I'm going to go capture it so I can have that memory forever. And maybe she can put a picture of herself up on her wall, because you know what, she doesn't have a whole lot of those things, and she is a very, very kind person. And I love her very much. So, oh, damn it. I'm an idiot. Hang on. There you go. Let me copy this to the other ones too. Lego Lad 659 requests doggos. Can I get some doggies? Here's a ball. I bet you I can get some doggies to play ball. Move my camera bag so nobody crashes on it. Yes. Get that out of there. Well, there could have been worse. Hey. Good catch. How are you? How has... Oh, that's a flea. Be right back. I swear his flea treatment doesn't work at the end of the month. And I catch him jumping off of him. Come here. Where's that ball? Ilsa, bring the ball. Ilsa, come. Yes, because they don't understand why we're playing the ball in here instead of going out. Yes, the dogs get a monthly flea treatment. They take it orally, and for some reason at the end of the month, it seems to like wear off. So he doesn't have fleas. I'm pretty sure about that, but like occasionally I find when jumping, like one jumps off of him, I grab it and flush it down the toilet. They spend a lot of time outside, so I'm more than certain he could have gotten a flea outside, or gotten flea eggs laid on him outside. Ilsa, come here. Come here, I'll play ball with you. You have to give it up, though. Yosa. You have to give it. Hey, drop it. Nope. So, does anyone have any questions about the case? If I sound a little stressed out, it's because I now have a lot more work to do that I hoped that I didn't have to do, because I definitely have to respond to this thing that has happened. So, I have no beagle. I am a lesser being. I do not have a beagle. I do not have a beagle. I like beagles. You know what I did have? I had a German short hair / Springer Spaniel. That was my first dog. Steel Trap says that we should play some Amy Winehouse. Tried to make me go to rehab, but I said no, no, no. Oh, I'll put that one on the list. So you've actually hit upon something. You may not know it, but earlier today I was in my music channel on my Discord discussing what songs we might cover if I did a karaoke segment to the 100,000 subscriber show, assuming that comes sometime in the future. So maybe I'll add that to the list. Mario Benales, 150 Mexican dollars, pesos, MX, I think that's what that is. Keep up the good work. What kind of keyboard do I have? Are we talking about a computer keyboard, or are we talking about keyboard? Because I have a computer keyboard. It's a Corsair 65, a Corsair Cherry MX 65, I think it is. It's the shorty with the arrow keys, but without the number pad. And then I have another keyboard, my Roland RD700 SX. It's a full-size 88-key, progressively weighted key performance stage keyboard that I expect I'll be able to bring. What did you do to yourself, buddy? What did you do? You got a tick? No? I don't know what he did to himself. He's got a little scab on his eyebrow. I'll check that out later, buddy. I don't know what you do. You're a good boy, though. Yeah, it's nothing alive. It's just a little scab. Maybe the flea bit him, and he's having a little reaction again. See, that's the thing, though. If a flea bites him, and he's got he's taking that pill, it kills the flea, and then that's probably how I can capture them so easily, because they're like half dead from having bitten a flea repellent treated dog. Dumb fleas. But he's allergic to fleas, so he gets a little spot. He gets a little hot spot. So, anyway. So, questions or these were Cherry MX Red, I think. I think you can I gotta check to make sure which. I think you can hear it. They're rather loud. If no lawyers think they can win for the client, they shouldn't take the case since it'll cost them and their clients. Yeah, so that Rule 11 pleading standard that we went over, that standard is why an attorney would not be able to take Alex's case as is and would have to only present the parts of it that were meritorious, because the lawyer then becomes liable for presenting a frivolous case if they present a frivolous case. Can Alex claim repossessed copyright in lieu of pay? No, that's not a thing. That's not a thing. What she's claiming is that she wasn't paid properly under her contract, which is a contract law violation. And so if there's a contract violation, you go to court over the contract violation. It does not negate the contract. It does not void the contract. It does not make the contract voidable. It just means that there's a dispute over the terms and performance of the contract. So if Alex has a dispute over the terms and performance of the contract, or should I say, if Alex had a dispute over the performance and terms of the contract, she had until September 25th to file her response. And she did not send it in until September 26th at about 3:50 in the afternoon, about 3 hours after I filed for the entry of default, and even then it was not complete, it was not signed, and it was not in accordance with the minimum rules for putting things on the docket. So I'm very sorry, Alex, but you didn't get it in on time, and I'm going to be asking the court to not recognize it, basically. Hey, Leonard, have you ever seen that Rick and Morty reading? Yes, I have. That's amazing, and we have plans to do things like that. For example, I am working on an Abbott and Costello performance. The Abbott and Costello Who's on First routine. Versions of it are off of copyright, and so able to be performed by anyone without any restitution or licensing. So I'll be working on that, and we'll have a whole video about what the status of that is and how that works. Has anything crazy like that happened in a court case? Yes. I don't know about in a courthouse near me. I don't get a chance to see all the court cases, but I've definitely been a part of a few crazy cases where people had very interesting interactions with a judge. For example, I had a client that was belligerent against the opposing party and really would not let them say anything. Like, my client was having trouble keeping themselves quiet, and the judge literally told them to go stand in the corner. It was very it was not amusing to be the lawyer representing that client. At one point, the judge asked what notes I was passing to the client, and I had to explain to the judge that I was doing my level-headed best to keep my client quiet and behaving appropriately. And the judge smiled and laughed and thanked me. Andrew DeMarco, $10. Thank you. Mr. French, I am a Philadelphia law student writing an article that uses this case as an illustrative example. I just learned about your videos today. You can email me sometime to discuss. I'm going to be busy from about 3 o'clock today till about 8 o'clock tonight, and then definitely taking some personal time tonight. But tomorrow I should be able to respond to you, Andrew. Please feel free to email me. You can find my website in the description and contact me through that email address if you'd like. So what happened with the response? Well, there's a response that's in the description. The response is 1 page. It makes only modest legal sense. Yeah, I'd give it a 3 out of 10. It wasn't the worst I've ever read, but it definitely doesn't quite make the claims, and it more or less admits what we've been saying. And while trying to, I'll argue that it's obfuscating, that it's trying to muddy the waters, trying to make it more difficult to resolve the claim. But that wouldn't be normally what an opposing party would do if the response had been filed on time. This seems very insincere, and maybe even negligent. Maybe even intentionally malicious. So I'm going to make those points in an epic pleading where I ask the judge to strike all or part of her response, that I ask the judge to dismiss all or part of her response, where I ask the judge to impose sanctions on her in the form of striking her response or denying her late response, and requiring her to pay restitution. I might even ask the judge to require her to post a monetary bond before making any further filings to cover whatever the expected responses are, because now, instead of a default judgment, which I should have, and we should be able to, it only cost a couple $100 for me to file something like that, so now I have to write something that is more like 10 or 20 hours of research. So at my half rate, between $1,200 and $2,500 will be spent, which is, I'm fine doing the work, thank you all very much, but at the same time, I would like to see that money go towards Dawn and go towards the Penny Arcade's child play that we're going to be donating the remainder of the funds to. So, while I don't think that we are anywhere close to running out of funds, I have been very careful about managing the funds, and we have a very significant portion of the funds left, approximately half. I do expect that it will not be enough to cover the judge allowing this response. If the judge denies my motion and allows Alex's response, there will be a lot more involved in this case. If I can get rid of Alex's response now, using this motion, then the case is done. And honestly, for it being late, I should not have to respond to it. It does appear to me to be only to increase the costs and delay the litigation. So Alex did not engage an attorney that I know of. An attorney did not sign this document. Here, I'll put it back up on the screen. An attorney did not sign this document. Alex signed this document. So I do not expect that... Oh, good, we still have music? Okay. I do not expect that an attorney will suddenly appear in this case, or that the attorney has been involved since August 21st. While I don't expect that a judge would deny her the opportunity to get an attorney now, I don't know that the judge would allow her and her attorney to have a meaningful interaction with the case after she has so neglected to have a meaningful interaction with the case. Pierced Brosman, thank you again for another Norwegian kroner 50. Wouldn't her past DMCA actions function as evidence that all her actions are malicious and meant to cause damage and damage alone? Yes. Yes, and I could be using some of that. I might use some of that to back up my allegations that this is all malicious. Instead of just saying that it's malicious, I will back it up with some evidence. Also, why this is not going to be something that I file tomorrow, probably not even Monday. I forgot that it's already Thursday. So it'll probably be the end of next week before we are able to file our response. If the judge... Here's the best thing that could possibly happen. If the judge recognizes what it is on the docket, and on his own, because it did say that the judge could strike it on his own, then the judge... If the judge was to strike the pleading on his own, that would make things much cheaper for us. I have to do whatever happens, unfortunately. Yeah, here's how the pleadings work. She sent the pleading in, and as long as it meets the minimum definition of a pleading, which this is close enough, then it goes on the docket, which is the record for the case. That doesn't mean that anyone approves or disapproves of it. It just means that it's made it onto the docket. So the judge may not have even seen it. In fact, the judge's clerk was the recipient of this document, and I have my doubts that she showed it to him until it was in its proper form and filed on the docket, because that's the standard for these things. You can't send things to the judge directly. They go on the docket. So once it's on the docket, I suppose the judge now has it available to him. So it's possible at any time the judge could issue his own order striking it from the docket. I would absolutely love that. That would be great. But at the same time, that's not typically how these things work. It does have the color of some kind of a response, and the judge will probably require me to make my response. Black Sun 388 gives $10. Thank you very much. If this is stricken, then would it not be permissible for use by YouTubers seeking legal action against Mauer for damages from her false DMCA strikes? Sort of, yes. I wouldn't say yet. What you want to wait for is for us to get a piece of paper from the judge that says we own the copyrights and Alex does not, and then you can very confidently begin making videos again. You can probably very confidently make videos now, but the confidence would be, you'd be confident that we would use it as evidence if she took it down. Now, your video can't be complicated. It can't be a non-Alex Mauer video, or it can't be an Alex Mauer plus video that has other infringing things on it. If you were to make a purely a purely permitted use video of Starmazer or Starmazer DSP and Alex took it down, then yes, we could help you with that. Just to be clear, some examples will not be able to be pursued if they are not clean examples of takedowns. For example, if someone put up a video that had Starmazer in it as well as other Alex Mauer music that she does properly own, then we could not take that down. We would not be able to go to court to help you with the takedown that she issued, because she'd issue a takedown for you having any of her content in your video at all. So, my Alexa just responded to you. Sorry about that. It was unintentional. All right, so how are we doing? We're at an hour and 30 minutes here. I think this is a great time to end the stream. Is there anyone that has anything left to ask before I go over my closing? So, once again, Alex has submitted a late response that makes some sort of claims and doesn't really make much sense other than that. And we will, I'll be answering it with a fairly comprehensive legal proceeding, legal document, a motion to strike, a motion to dismiss, a motion for sanctions, motion to dismiss her claims, a motion for sanctions, a motion for contempt. So that will all be one epic legal document that I'm just so looking forward to having to write now that she has not responded and then responded. And I'm going to ask the judge to basically not allow her response as both being late and for an improper purpose. Sveinung, yeah. Norwegian Kroner 100 from Sveinung again. Please correct me if I'm mispronouncing your name. Maybe you should say, Alexa, buy 3 gallons of lubricant and see what happens. Metis, €5. Can you explain what is unlawful and illegal? I don't understand the difference. As far as I know, one is against the law, the other is a sick bird. Unlawful and illegal they basically mean the same. I use the word unlawful sometimes because illegal, if I misspeak or if the stream skips, it sounds like I'm saying legal. That is legal or that is illegal. It's hard to miss that ill in there sometimes, so unlawful is a lot more clear of a word to say than illegal, which is why I use unlawful instead sometimes. Leonard, do you think her response was prompted by your original video? No. I think her response was prompted by my filing the entry of default. I filed it at about noon 30 on the 26th, and she responded to the court at about 3:50, about 3 hours and 20 minutes later, after I had emailed our default request to her. I agree, but unlawful is a bit easier to say than illegal, so we'll just have to be ultra clear on that one. Regardless or irregardless, I want to thank all of you for joining me today. This has been another epic live stream that I'm happy to bring to you, but it would have been much nicer if we were talking about the default being entered. I am Leonard French, your favorite copyright attorney. I would like to thank my supporters on Patreon. Again, this live stream seems to have been demonetized. I don't know if that means all future live streams as well. Appears to have been demonetized, and so I could really use your support on Patreon instead. If you like these weekly live streams, please consider supporting me on Patreon. My $50 plus supporters on Patreon are currently Joshua Meinsiker, John Steele, John Cripps, Nate Beck, Lydia Collinson, and Weston Loney. The rest of my Patreon supporters will be in the description below, and will be and are scrolling on the panel that's sort of flickering because it's set to the 50 hertz for my camera, for my good camera, and not for the whatever the frame rate is on this thing. I'm Leonard French, your favorite copyright attorney. I will ask the dogs to come back in here. Does anyone want... anyone? Oh, you missed. You missed. Try again. And then she's going to take the ball away. Nico, could you go get the other ball? Nico, get the ball. Nico, go get the ball. Go get the ball. Nope. No, go get the ball. That, yeah, no. Eat Nico, go get the ball. There you go, good boy. Get the ball. No, don't point it out to me. He's just pointing it out to me. Would you bring the ball over to me? Can you come up? Yes. Yeah, Nico, come here. Up. Nico, come here. Oh, now you bring it over so you don't have to come up. Okay. Good boy. Oh, what a good boy. Can you go up? Yeah, you can. Yeah, you can. You're yes, you can. It's stuck in your paw, honey. It's stuck in your paw. Okay, honey. There you go. There you are. Happy dog. Happy dog. Happy dog. Happy dog. Arg. Happy dog. Rah, 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 rah. Rah. Oop, you lost your ball. Rah. Good boy. Good boy. Good boy. Thank you again, Mo, for the 10 euros. Appreciate it. Alright, guys. I'm going to sign off and get ready to go see my mom get her award. I love you all. I'm Leonard French, your favorite copyright attorney with your favorite dogs. The such dogs, as we call them. And I'll be back later. Love you all. Hey Alexa, send 3 gallons of tennis balls to Leonard French. Alright, I'll see you guys later.